I was trying to put Kip White's, which is Katera's father, on child support with two other fathers I have for my other two kids as well. And I was going back and forth court for that. So there was never nothing said to me. And then today, on this day, I'm now hearing about I owe child support. Well, how do I owe anything?
Okay, pausey. She just dropped a bomb. She's being told she owes child support when she thought it was zero. Imagine showing up to court thinking you're getting justice and walking into a financial ambush. How does that even happen? Let's see if the court clears it up or just gets more confusing.
If I owe anything, it's supposed to be at zero.
Davis and Whitus.
Miss Antoinette Davis and Miss Felicia Davis, Judge.
Okay.
Well, don't say no fucking bitch for me.
Sign your life off the big day.
Do each of you solemnly swear or affirm that the testimony you're... Ms. Davis, can you leave your right hand raised, please, ma'am? Do each of you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth,
see the people
and nothing but the truth?
I see the judge.
They're gonna show her too.
Yes. Yes, Your Honor.
All right. Thank you both. You may lower your hands. And Mr. Dell, you may proceed.
And Miss Davis, have you received an email this morning from the Office of the Attorney General that includes a copy of the legal pleadings in this case?
Yes, sir.
And you understand that you have the right to be personally served with those documents at your residence by a process server or a constable?
Notice how she waives her right to be served in person. This might seem small, but it's legally significant. It means she's giving up the chance to fight improper notice later. Always think twice before waiving rights, even in something as harmless as an email service.
Proceeding with the case today and finalizing the case?
Yes, sir.
Your Honor, I pass the witness pass the record reflect that Miss Antoinette Davis has voluntarily waived her right to personal service and citation.
The record will so reflect.
Thank you, Judge. Your Honor, we're here today on the state's motion to confirm support arrearage. This case only concerns, or was only pled that to confirm arrears from mother, Miss Antoinette Davis, to child's aunt, Miss Felicia Davis. As such, Mr. Whitus is not a party. Excused.
Okay, you may proceed.
Your Honor, I'd like to offer in evidence what's marked for identification purposes as State's Exhibit A copy of the payment record in the case.
State's Exhibit A is admitted.
Thank you, Judge. We have a mostly agreed order today, Judge, with a release. I'd like to state the agreement and then take testimony.
1 second. You may proceed.
Thank you, Judge. There is one child of the case who has since emancipated. Miss Antoinette Davis was previously ordered to pay $100 in child support beginning December 1st, 2007. Parties agree that Miss Felicia Davis shall release child support arrears of $6,238.10, Judge. As such, the state's requesting that a child support judgment be granted against Miss Antoinette Davis in the amount of $4,678.20. The state's requesting a repayment of $25 a month beginning March 1st, 2025.
And here's the twist: Felicia is releasing over $6,000 in child support arrears. That's huge. But before you think it's all generosity, remember, there's still a judgment coming. Keep your ears sharp. This courtroom isn't done dealing curveballs yet.
Proposed order, Judge. May I call Miss Felicia Davis first?
You may.
Judge. Ma'am, what is your full name?
Felicia Davis Lucky.
And ma'am, did you hear the terms of the proposed order that I stated to the court?
Yes.
Do you understand those terms?
Yes.
And you're agreeing today or asking the court to release some money that's owed to you. Is that correct?
Yes.
And are you releasing that money freely and voluntarily?
Yes.
Has anyone threatened you or coerced you into releasing any money?
No.
Hold on
You
one
understand?
second, Mr. Dale. Miss Antoinette Davis, I'm not sure who you're holding a conversation with,
I'm
but
listening to y'all. I couldn't hear you.
okay, well, it seems to me like you're holding a conversation with someone. You need to have your attention over here, ma'am. Thank you. We're in the middle of a hearing.
There's no one here, ma'am.
All right, thank you.
You're very welcome.
Go ahead, Mr. Dale.
Miss Felicia, and do you understand that once that money is released today, that you won't be able to come back and ask for it at a later time?
Yes.
And do you agree with the terms and believe that they're in the best interest of your child, of the child?
Yes.
And do you have any safety concerns on the case, ma'am?
No.
I passed the witness judge and like to call Miss Antoinette.
You may.
Miss Antoinette, did you hear the terms of the proposed order that I stated to the court previously? Do
Yes, sir.
you understand all of those terms?
Yes, sir.
And do you agree with the terms that I stated and believe that they're in the best interest of your child?
Yes, sir.
And do you have any safety concerns on the case?
No, sir.
Your Honor, I pass the witness.
So, Miss Davis, you're agreeing to all, Miss Antoinette Davis, you're agreeing to all the terms?
Yes, ma'am. Wait. You mean like far as what he says to Felicia Davis?
Yeah, that you owe her $4,678.20 and that you'll pay it at $25 per month.
No, ma'am. I thought you said that she was releasing arrears. You talking about paying the state?
The classic court confusion moment. She agreed to some terms, but not the $4,678 debt. And here's the emotional crux: she believes this should have been resolved years ago. What would you do if the system kept changing the rules?
Per month.
So no, ma'am. So I just discussed that with him in the break room, that when we came to court, that I was at $0 balance, and we did a modification, and it was told that I was owed $9,000.67.91. Then he told me to, when I come before the judge, to ask the judge to see what she can do, because I was saying that I'm just at the point where my daughter's 19, and we've been dealing with this since 2010. When the child came back home, we was under the impression that the reason why Kip was called to court was because the modification was going to go towards him, because I've been taking care of my child the whole time, and me and my auntie signed the affidavit when we went to court before COVID hit, where I was at $0 balance, and then you guys' attorney said you guys owed me money, but now it's because the years have passed and it just keep on going and going, and courts has been coming and coming. Now it's saying that I owe, and that's why I was confused at. So if you always see, they'll take my income tax and they'll give it back, and then it'll go up to Austin, and then I'll get contacted by Austin, and they'll send me a check in the mail because it was told that I was owed money. Now they're saying that I owe them money, and that's why I was confused at, because this is supposed to have been over with, and that's why we thought we was coming to court to put Kip on child support, not that I was owing money. So we was just in agreement to saying it was going to be took away, because my daughter's 19 and she graduates this year, so I'm just over it because it's holding my credit down. This child support stuff that I don't understand how I owe when it was at $0 in 2010.
Your Honor, Miss Antoinette was previously ordered to pay $100 in child support back in 2007. In 2018, Judge, her child support was stopped due to the child living with her. It was not modified, it was just the obligation was stopped. At that time, there was about $8,800 owed, if you, according to the pay record. Since that time, interest has accrued. There was a change of status filed in late 2019. That was eventually non-suited. There may have been some money on hold at that time. There's no money on hold now. The state is in agreement today to release all the money.
The classic court confusion moment. She agreed to some terms, but not the $4,678 debt. And here's the emotional crux: she believes this should have been resolved years ago. What would you do if the system kept changing the rules?
So when you say it was stopped but not modified, it was not modified to $0. They just stopped withholding?
Well, it was modified to $0, Judge. What I meant was it wasn't retroactively modified. So what was owed at that time
was still owed.
And then interest continued to accrue until today.
Okay.
child is since emancipated.
Okay. So Ms. Davis, you heard his explanation. Do you have anything else you want to say? You're muted, ma'am.
I'm sorry about that.
That's okay.
No, ma'am. So that was not what was told to me from the attorney. For Attorney General was told to me the amount that he just said with interest was $9,031.91 was owed to me, due to them taking the money, my income tax, and my auntie signing off on the affidavit saying that she didn't want any money to herself because the child has been with me. It was just a mix up. We kept going back and forth, back and forth, and back and forth, and back and forth to court. Then COVID happened. Then we kept going to Zoom meetings and we kept getting rescheduled. So then when I finally went to court, it was said the money was owed to me. So then they stopped it and put it at a zero balance because I said that I was just like how I am today. I was like, I just want this over with because I'm taking care of 3 daughters and by myself. So I'm like, I just want it over with. I don't even want the money. If it's going to be zero, I just rather do it at a zero. So then I signed off on the paper and they said I was at zero. I didn't have to worry about it. So my auntie, she didn't have to come back to court. I didn't have to come back to court. The only time I would have to come to court is for Kip because we've been trying to put him on child support since 2008. So today when I got this court date, I'm thinking, oh, it's me, Felicia, and Kip. We're thinking we putting him on child support, not me coming back to court for me again for his real. So I'm like, how do I owe anything? It's supposed to be at zero.
And thank you, ma'am. Mr. Dell, can you share the pay record with me?
I already seen the pay record.
No, I want him to share it with
you. Okay. I'm going to push myself back on mute, Judge.
Yes, ma'am.
I can, Judge. I'm on Zoom on my iPad, so it is going to take me a moment.
Okay. At any point, does the pay record show a balance of zero, Mr. Dell?
No, Your Honor.
Okay, thank you.
Can you see, Judge?
I can. Can you enlarge it or can I?
Yes. Okay. So $100 was ordered back in 2007, December 1st.
Mm-hmm.
And that continued. Miss Antoinette was paying. There were no payments beginning April of 2012. As such, the support was accumulating. And then we stopped the $100 payment obligation. October 1st, 2018 was the last month of the $100 obligation.
Okay.
And the remainder, that $43, is interest. There were a couple of payments.
Okay.
And so in October 1st, there was about $8,700.
Okay.
And then with interest, and then today it's $10,916.30.
Okay. Thank you, Mr. Dell. You can stop sharing your screen now.
I'll try, Judge.
Okay.
Yep.
Thank you. All right. Is there anything else you'd like to tell me, Ms. Davis?
Yes, ma'am. So if you was to look at the rears, on February 26th, it was a credit to me. That's when it was told that from their attorney, from Attorney General attorney, was told to me that I wasn't going to pay anything else, and there was a balance owed to me. I don't have the thick paperwork that I got from court that day, so that's why you don't see any payments from that day. You see a credit balance on that day from the 26th of February of 2012. That's when the payments would stop from the court date, and that's why it was a credit balance right there. Then you see after that day, it just started jumping up, and then they started putting it back on there. Then we went to court again in 2018, and I was told that it was the money that was back paid, which was a balance of, like he said, $8,800 plus the interest was $9,031.91 will be paid to me, and then that the court, we had never heard anything else about it. At that time, I was trying to put Kip Weichers, which is Katera's father, on child support, with two other fathers I have for my other two kids as well. And I was going back and forth court for that. So there was never nothing said to me. And then today, on this day, I'm now hearing about I owe child support in 2012 from the day when I had a credit balance. If you look at those rears where it was a credit balance for me, was owed to me, and then it picked back up after blue, and then I was told at the attorney general office in Duncanville that the system has something where it just backdate or something as that well, and it's not being very transparent, Judge. I've been working, so they'll take child support from me and then they'll stop it because they say that I don't owe, they owe me. That's why it keeps double back, and there's no way I can be owing this much money and I work, and there's no way child support keeps sending me checks every time they take my money, because it's a mix up in the system and it just haven't been fixed.
Okay. From what I saw on the pay record, I didn't see a credit anywhere.
Yes, if he pulls it back up, I have the same paper in front of me. That's what I was looking at as well. If you pull it back up, it's a credit right there on February 26th.
The balance never went to zero, even with a credit. It never went to zero.
It did right before that. It was a balance of zero. Probably 3 payments before that, and then there's a negative sign after that.
I never saw a balance of zero. The balance column never said zero.
Yes, ma'am. If he pull it back up, it's on there.
Okay.
I mean, we looking at the same paper. I never
saw a balance.
I can tell you the date.
But she was current in summer of 2012, and then payments. But the obligation.
I'm talking about after 2018. I never saw a balance of zero.
Right, because that's what I'm trying to tell you. When I went to court, there was never. It was told in 2012 that I wasn't paying child support anymore. The child was at home. There was no child support. It was telling me to do a modification. I did the modification. That Kip was going to be on child support, and that's what it was the last thing I was told.
Yeah, Miss Davis, that's probably correct, but they never did the modification because they evidently could never get in touch with him.
But how did
child support kept accruing? It kept accruing. It kept accruing because the child support kept accruing until they modified your child support to zero. So now that I've seen the pay record, this will be my ruling. I will accept the agreed portions of the order, which is the release of the $6,000. And I will order a child support judgment against Miss Antoinette Davis in the amount
And there it is, final judgment. $4,678.20 owed. $25 month payment plan, plus court costs, and the kicker. She has the right to appeal. If you were in her shoes, would you fight it or walk away just to have peace?
I made my ruling. If you don't agree with it, if you think it's not fair, you have 3 days to appeal, 30 days to file a motion for new trial. This is out of the 305th District Court. That is, not a district court, that's a juvenile court. And you can appeal to them, and they might have a different opinion from mine, okay? Ms. Davis, do you have any questions?
You said I can appeal it? That's what you said?
Yes, ma'am. Yes, ma'am. To the 305th juvenile court. Okay?
Okay.
Anything further, Mr. Dale?
No, Judge.
Do either one of you have any other questions?
No, Your Honor.